Good afternoon, everyone. Welcome, welcome, welcome. Wherever it is, you're watching from. Good morning, good afternoon, whatever time it is you're listening from. My name is Oluwatoyin Modupe Asada. I am managing partner at Sunesis DLP, but today I'm here in my capacity as the co-chair of the Lagos Committee of the British Nigerian Law Forum. And I'm very excited to be given this opportunity to moderate or steer today's webinar, this conversation. But before we proceed, I think it's important for us to talk about why we are all here. This is a flagship event and it's very significant. Last year in June, the British Nigerian Law Forum launched, or let's say, had its very first Nigerian summit. And as part of the programs of the day, we had a fireside chat between the BNLF, that's the British Nigerian Law Forum, and the Nigerian Bar Association section on legal practice, and the Nigerian Bar Association section on business law, where we spoke about how we can all synergize and ensure that we can rub off on each other our strengths to propagate our mandate, which is to build capacity for lawyers, especially, in the business sector and also in disputes, legal practice in general. And the essence is just to foster sharing of knowledge, helping ourselves. The world is evolving. There's so much happening. So how can we help each other? And so we came up with this initiative to host webinars, to collaborate, host this webinar so that we can bring people of like minds, experts, to teach us different things, to share knowledge, to build capacity, so that we can incorporate this knowledge into our practice and into the bar as a whole. And I'm so excited that today signifies the beginning of what is going to be a very insightful and, life-changing experience for every one of us, because today we have chosen to start with a very relevant topic. And like I said, we have the MBSBL on board, the MBA and SLP, and the British Nigerian Law Forum. So the topic for today is the future ready lawyer, innovation, technology, and collaboration across borders. We thought it best that this topic is very, very relevant. We hear AI every day, but what does it mean for us? We have seen how it's radicalizing legal practice, from contract reviews to compliance to dispute resolution, and it's even shaping cross-border transactions as there's more fintech work now, there's more investment, diaspora business. We are becoming one global village indeed. And the UK and Nigeria has a very unique relationship from time immemorial. So we thought it's best to talk about this topic from a position of how lawyers can not just be consumers, but intentionally incorporate these innovations to suit them. We do not want to just consume, but we need to understand how this fits into our context. We want to be a part of it, but in a way that comes from knowledge and understanding. And today we have brilliant minds who would be steering us, giving us information, giving us knowledge on how these things actually work. So this is how it will work. We would have two panel sessions. One will be moderated by our amiable vice chair of the BNLF, and then we come back for the second panel, which I will be moderating. Like I said, we have stellar speakers, people who are doing very well and very well equipped. We took our time to source for them to educate us on these issues. So, but before we move into our panels, we would like to bring to the fore to give their keynote speech and goodwill messages the presidents of these organizations before we set the ball rolling to move proper into today's webinar. And so without further ado, I would like to bring up firstly the chairman of the British Nigerian Law Forum, in the person of Mr. Kash Balogun, to give his opening remarks. So, Mr. Cash, please go ahead.
So good afternoon, everyone. I hope you can hear me.
Yes.
Great. And my apologies for the slight delay. I was having some technological problems. I'd just like to thank everyone for joining us today. My name is Kash Balogun, and I'm the chair of the British Nigeria Law Forum. I'm also a partner at Keystone Law, an international law firm headquartered in the UK. It's my pleasure to welcome you all to today's webinar, which is hosted by BNLF in collaboration with the Nigerian Bar Association section on business law and the section on legal practice. This is our first collaboration of a webinar of this nature, and it was following the commitment we made at last year's two-day BNLF Nigeria Summit Conference to deepen our engagement with the Nigerian Bar Association through more shared programs. For those of you who may be less familiar with BNLF, our organization has now been in existence for 25 years. This year is our 25th year anniversary. Over that time, we've grown into a truly vibrant community. Our objective remains very simple. It's to strengthen professional bonds between lawyers in the UK and our counterparts across Nigeria. We pursue this through thought leadership, professional development, and collaborative initiatives that support excellence, innovation, and meaningful cross-border engagement. Now, one of the things I really value as chair of this organization is seeing the active involvement of our members at all levels, from students and junior lawyers to senior partners, judges, and academics. I'd like to take this opportunity to extend my sincere gratitude to our co-hosts, the NBA SBL and the NBA SLP, and especially to their chairs and the organizing teams from both sections. Your enthusiasm, partnership, and hard work, along with the efforts of the BNLF organizing team, have made this webinar possible. I would also like to thank our panelists for giving their time and insight today. Each of you brings a wealth of experience across innovation, technology, and modern legal practice. I know we will benefit greatly from your perspectives on what it means to be a future-ready lawyer in an increasingly interconnected world. Our profession is changing rapidly. Technology is reshaping how we advise clients. Expectations around agility and value continue to rise, and our cross-border work has become integral to commercial practice. Conversations like this help us not only to understand the shifts taking place, but to position ourselves and our firms to thrive within them. I hope you find this discussion today stimulating, practical, and inspiring. More importantly, I hope they encourage continued collaboration between our professional communities here in the UK and in Nigeria long after this session ends. Have a great seminar. Thank you all.
Thank you very much, Kash. Thank you for your well-put introductory remarks. So right about now, I would like to bring up one of our co-hosts as well, someone who I personally really admire, who's been a mentor, who has been a trailblazer in the legal profession, and the person of the learned silk herself, Mrs. Folashade Ali, SAN. She is the chairman of the Nigerian Bar Association section on legal practice. She's here to give us our opening remarks.
Thank you very much, Toyi, and thank you, Kash, for those introductory remarks. Good afternoon, distinguished learned colleagues that have joined us this afternoon, and the respected leaders of our profession, and all participants who have joined us from Nigeria, the United Kingdom, and beyond. For me, today is really historic, because for the first time in the history of the Nigerian Bar, the section on legal practice, the section on business law, and the British Nigerian Law Forum are coming together to organize a joint webinar. And for me, the webinar reminds us that the future of the profession will be defined subsequently by collaborations such as this, and not isolated efforts by each and every one of us. I mean, there's a saying that says, if you want to go fast, you go alone, but if you want to go far, you go together. Today, we, the British Nigerian Law Forum, the Section on Legal Practice, and SBL choose to go far together. I've just been informed by Rex earlier on that over 3,000 participants have logged into this webinar. And I'm quite sure before the end of this webinar, we'll have double the number of participants. That for me is the power of collaboration we're talking about. Although each of our associations have different mandates within the legal profession, but we have come together to assist all legal practitioners to gain rich experience we all need as lawyers in this fast-changing world. As you know, SLP is focused on regularizing the standard of the legal practice, how we sustain integrity of our profession, whilst SBL reminds us that law does not operate in a vacuum. It enables commerce, investment, and economic growth. The British Nigerian Law Forum is focused on cross-border practice, and as you can see, sharing knowledge, global engagement. But we've all come together with the recognition that the modern lawyer must sit at the intersection of both practice, business, and the global engagement. And that is why I think the theme today is very apt: the future-ready lawyer, innovation, technology, and collaboration across border. As the chairman of BNLF just said, he said, technology is changing. Now being asked not only to interpret the law, but to understand industries, technology, and risk in a fast-changing world. And technology informed. So for all of us, I just want to say, it reminds us that we must share.
It appears Leonard Silk is having some network issues, or is it just me?
And challenge the assumptions. So on behalf of the chairs of all the sections present here, I thank all the speakers, panelists, and those who have organized this for their commitment to ensure that we have an impactful joint session. Once it's done, I wish all of us an engaging, insightful, and impactful discussion. Thank you very much.
Thank you very, very much, Leonard Silk. Very well said. And indeed, it's very impressive to see the number of people that we have registered for this webinar, 3,000. Remarkable. And it shows that we distinguished learned minds on this webinar are very, very future forward indeed, and we're at the right place. If you're just joining us, this is the flagship collaborative webinar between the BNLF, the NBSBL, and the NBA SLP. And so far, we've had the chairman of the BNLF and the chairman of the NBA SLP give their opening remarks. And now it's time for the beautiful, this is Ozofo Latunde Ogemudia, who is the chairman of the Nigerian Bar Association section on business law, to give our opening remarks.
Thank you so much. Good afternoon, Leonard's colleagues, Leonard senior colleagues, senior advocates here present, colleagues, ladies and gentlemen. Good morning, afternoon, or evening, depending on where you're joining us from. Like we've said, we have more than 3,000 registered, and we know we have people from various jurisdictions joining us. And you're very welcome to this webinar. It's such a joy to see that months of discussing and planning collaboration between the BNLF, the NBA SLP, and the NBA SBL has resulted in this first outing together. And I know it will be the first of many. I want to thank sincerely the leadership and members of the BNLF. They put a lot of energy and time into preparing and delivering this. So thank you very much to the NBA SLP as well for the spirit of collaboration with which we are doing this together, and for your shared commitment to strengthen our profession alongside the BNLF across borders. Today's theme is the future-ready lawyer, innovation, technology, and collaboration across borders. And it is very timely because, as we all know, technology is reshaping how we work, how we serve our clients, how we create value. And that's a challenge that we all face. Clients always want to know, what's the need from me? What's the value you bring? What differentiates you from your colleague down the street? And I think innovation is that differentiator. It's no longer optional for lawyers. You can't say, I'm not a tech person, I'm not interested in tech. It is essential. At the same time, our legal work is increasingly cross-border, which means collaboration and a global perspective are more important than ever. These conversations build on work that the SBL has been doing over the past year. For instance, our last annual conference was on the theme, the future of business law in an intelligence age. And this shows that this is not a one-off conversation, but it's a deliberate and ongoing engagement. We're very fortunate to have a distinguished panel bringing perspectives from practice, policy, technology, and cross-border engagement. And I'm confident that the conversations we're going to have today will be both insightful and practical. I would like to add my thanks to our speakers who are giving freely of their time and expertise that they've built over decades of experience with us today. It is very much appreciated. I encourage all of us to participate actively, to share, to ask questions, and to ensure that we take something away from today's deliberation. So on that note, I'd like to thank everyone, our partners, our speakers, and all our attendees. You've made this really meaningful, and we look forward to today's discussions. Thank you.
Thank you very much, Madam Chair. Very well put. And I want to say a very big thank you once again to the SLP and to the SBL for being so magnanimous and collaborating with BNLF in making this a success, which I believe it already is. And thank you also to all learned seniors, senior advocates, learned colleagues for taking our time on a weekday to invest in knowledge and being a part of this. And I believe it will be worth your time. So it's time to move into the meat of this. And I'm going to be handing over to my distinguished Vice Chair of the British Nigerian Law Forum, the person of Genevieve Wakely-Jones, to steer the ship for the very first panel session of this webinar. And I'll be back for the second session. Genevieve, over to you.
Thank you so much, Toyin, and good afternoon, everyone. Good afternoon, distinguished colleagues, learned colleagues, and guests from wherever you're joining from over the world. My name is Genevieve Wakely-Jones. I'm the Vice Chair of the British Nigeria Law Forum. I'm a corporate and commercial partner at the UK firm of Kingsley Wood. I'm really excited to be steering our first panel, which is about who is the future-ready lawyer? This is a question on everyone's mind in this new era of rapidly changing digitization, changing client expectations, and increased global collaboration. Practitioners want to know, how do I adapt? How do I grow with this change rather than adopt a reactive stance? And with me to discuss this really topical issue are three extraordinary panelists who I will hand over shortly to introduce themselves. But just to give you a preview, I have Leon Hurd, who is a special counsel at Gosai Law, also partner at Keystone Law. I also have Adefunke Adeyeye, who is the global head of anti-counterfeiting and product protection at Halion. And also I have Viavo Humponuwusu, who is the managing partner at Blackstone Legal Advisory Services. So without further ado, I will hand over to Leon just to give a brief 1-minute introduction of yourself. Thank you, Leon. And then we can pass the baton to Adefunke for an introduction. Yeah. So over to you, Leon.
Thank you very much, Genevieve, for the very wonderful introduction. And may I say good afternoon to everybody, and my huge appreciation to being invited to contribute to this panel today. So, as Genevieve said, I am a special counsel at Kazai Law, and I also consult with Keystone Law. My practice area is essentially in regulatory law. I spend predominantly most of my time working with founders and startups and established businesses in helping them build out and develop products and services to roll out on a global and international scale, with a particular focus in emerging and disruptive technology. So, as you may appreciate, today's topic is quite close to home for me, just in terms of the types of people I'm around, and also sort of being at that frontier edge of technology and seeing its impact that it's having in legal services today. But I'll save some of that chat for later in the discussion. And I shall hand over now to my fellow panel members to give a little brief introduction about themselves. Thank you.
Thank you, Leon. Hi, everyone. My name is Adefunke, and I'm a Nigerian and UK qualified solicitor. I have about 20 years post-legal experience, and my career has spanned through a lot of industries and a lot of jurisdictions. So I've done media and entertainment in Africa. I've worked with Diageo, GSK, and currently I'm with Haleon, and I currently lead the brand protection and anti-counterfeiting team, which is part of legal. And my focus in law now is intellectual property. And today's topic is one that is really close to my heart because outside of law, I do a lot of mentoring for mid to junior level professionals that are just looking for how to navigate, their legal career. And it's quite an interesting one because I've realized that when you share your personal experience, it just gives hope. And people understand that law is not a dead end. You can actually succeed, doing the law. The only thing is that it's evolving and the world is changing. So knowledge of the law is not enough anymore. We need to do a bit more than just being a lawyer. So I'm really looking forward to today's session. And thanks again for inviting me to join this panel. I'll pass on to the next panel.
Viavo, yes. Thank you, Adefunke. Yeah.
Good afternoon, everyone. Thank you very much for having me. My name is Viabo Huponuwusu. I'm the managing partner of Blackstone Legal Advisory. We're a boutique firm that focuses on corporate finance, real estate, regulatory compliance, and also private client work. A lot of our focus is helping business owners navigate the business environment and provide legally commercial solutions to their problems. I've been in practice since 2009 in Nigeria. I have been running my firm 2 years after that. And I think I'm eager to see what the future holds as far as legal practice is concerned, because I think we need to be innovative. We need to be able to apply, not just know the law, but also apply the law to commercial situations. And glad to be here. Thank you very much.
Thank you, my extraordinary panelists. We'll now get into the heart of the discussion. So as the legal profession navigates this rapid technological change, so I'll start with one question posed to you just to have different angles from your experience. So as we navigate this rapid technological change, shifting client expectations, and increasing cross-border complexity, there are many traditional assumptions about legal practice, as you know, that are being challenged. So what I would like to really draw from your experience is, who is this future-ready lawyer? And how can law firms actively foster their development? I'll be keen to hear, if I start with you, Leon, just really interesting background, fintech, digital assets, crypto, regulatory compliance. What is your take on this question?
Yeah, no, absolutely. You can hear me. Sorry, I thought my microphone was off then briefly. Apologies. No, look, it is a really interesting question. I think one that I kind of draw on my experience in different firms and I look at it through that particular perspective. So I trained in a Magic Circle firm in London. I worked at a large national firm. I spent about 7 years offshore in Channel Islands, and I'm now working for an Australian headquartered international law firm, which is with a boutique practice on crypto and Web3, digital assets and fintech. So I've been very fortunate to see legal practice through a few different lenses and how it should be done. And so if I think to myself, what is that future ready lawyer? What are those qualities that I think are really needed to make sure that you're progressing in the direction, with the direction of travel, so to speak. I've kind of distilled it down to 4 things. And for me, it's being tech savvy. It's having a multidisciplinary approach. Importantly, having an international outlook, and finally being very flexible. And I'll just go into a bit of detail on each of those as to what I mean. So when I talk about being tech savvy, I don't think, it's a nonsense to think that you need to be an expert in every technological development that comes along, because quite frankly, it's impossible. Technology is constantly shifting, its use cases, what's being designed, what's being formulated, what's being invented, so to speak. But it is important to have an appreciation of it and to actually see and think actively, how might this technology impact on how I do things and how can I try and get ahead? I remember years ago, there being opportunities to think about blockchain and talk about how it might impact on legal services, how things like smart contracts might come into play. Those lawyers that invested that bit of time in thinking about that technology before it sort of really boomed were in a perfect position to take advantage of it. Similarly with things like AI, it's a hugely important tool that's pretty much going to revolutionize the way in which legal practice operates, because it actually allows you to do quite a lot of the digging work on an automated basis, and then allows lawyers now to spend more time on that kind of premium thin slice of the wedge stuff, really thinking about the issues and utilizing some of that, that support that AI can give you. So being tech savvy to me is having an appreciation about technological developments that are coming along and thinking ahead of time, how might I need to incorporate this into my practice area? How might I be able to use this tool to deliver a better service, a better quality of performance to my clients? When I think about being multidisciplinary, I think that's something that's becoming ever more important. I think clients nowadays just won't accept lawyers that are very much stalwart lawyers, just solely about the law. Clients want you to understand their industry. They want you to be able to work with not just other lawyers, but non-lawyers, work with developers, work with engineers, technical people, and be able to have meaningful conversations with them, not just to provide legal advice, but to understand how your legal advice impacts on what they're doing and overall how it might impact on a client business. It's something that I see a huge amount in terms of, with the clients I work with. If I've got a crypto exchange that's looking to roll out a product, they want me to understand not just the concept of blockchain or the concept of a token, but to understand a bit more intrinsically the types of tokens that exist, exactly how a smart contract might execute in this way, what particular blockchain you might go on and why. And these aren't hugely complicated areas to have to think about, but they are things that if you are aware of, it enriches the advice that you end up giving so much more. When I think about, international outlook, I just think, there's not a huge amount to say on this other than the world is becoming an increasingly small place. I can't think in the last 6 to 12 months of a single matter that hasn't had to sort of touch on a number of different jurisdictions, at least, 2 or 3 different jurisdictions. There's no client that wants to roll out a digital product just in the UK. They want to launch that product and they want to roll it out in the UK, in the US, in Asia, in Africa. And having an understanding about not just your own legal system, but different legal systems broadly and how issues might interact with them. So, how a light regulatory touch in one jurisdiction might have to be thought about differently in another one, again, enriches the advice that you give. But it's what I think clients are expecting. They don't come to you now thinking, we're just going to get legal advice in the UK. You need to understand, yes, I've approached you in the UK, in my instance, for example, but my business is global. Don't just give me advice that's relevant for one jurisdiction, because that's just one part of a much bigger puzzle. And I think that second part of the question that you mentioned, sort of how does one foster their development?
Yeah, let me pause you on that, Leon, but I want to hear more about the sort of how to foster their development. But I just want to get a global multinational perspective from you, Adefunke, if that's okay, if we can do in probably about 2 minutes. Yeah. And we'll come back to you, Leon, on that aspect here.
I was actually enjoying what Leon was saying because I could relate to a lot of it. And just like you said, tech savvy is one of the things that actually came to mind when you talk about a future-ready lawyer. Um, the reality now is everything is done, with technology, contract management, vendor management, managing your external counsel, you know, we're a global team. So I have team members spread across every region, and we have meetings at different time zones. But with technology, we can sort of manage how we support our clients. Again, it's not you understanding what AI is, what data privacy is, just have like a knowledge of it. And I used to joke a lot to the team to say that I don't know anything about technology, and I had to rely a lot on the team members. But again, multinationals are cutting the services that you have. So while you have the resources, you have to also equip yourself. So that's one of the things that a future ready lawyer has to embrace. The other thing is legal excellence and business acumen. So we're lawyers and we have the jobs because we've gone to law school, we have our legal degree. However, in a fast-paced business industry, that's not enough anymore. You need to have a deep understanding of the law, and it's presumed that you will have before you are given the job. You need to understand your client's industry, you need to understand the business model, and you need to understand the risk tolerance. So I've moved across a lot of industries, FMCG, pharmaceutical, consumer health. The only way I'm able to support my business is because I spend time to actually understand it. And I mean the nitty-gritty of everything, supply chain, sales and all of those things. You need to understand it. And when you speak the business language, you sort of gain trust with your clients. You need to be able to translate legal advice into practical business model. So you're not in a multinational to give them laws. You're there to enable their business and help them work. So your ability to be able to merge both together is what gets you ready for the future. You need to be open to learn new skills. A lot of lawyers sort of find themselves being rigid, to change and evolve with what is happening. But you need to understand alternative billing, again, for instance, is what we're practicing every time. You need to be able to operate effectively in an uncertain world. If you work for a fast-paced business industry, everything changes. They want to launch new products. They want to go into dangerous markets. They want to go into high-risk markets. You need to be able to advise them, know the laws, but help them deliver in these markets as well. And change is inevitable. Everything changes. The structure changes. Our ways of working changes. The admin support you have changes. So you need to be able to embrace the change. Importantly as well, be an effective communicator. You don't need all the legal jargons when you're talking to your clients or your executive team. They just don't care. You need to break everything down to them in simple language. You need to know your audience. You need to know you're not pitching something for a legal portfolio, but you're talking to not lawyers. You're talking to business-minded people. You're talking to people that want to make money, that want return on their investment. So you need to know that emotional intelligence, leadership, and collaboration. The higher you get in your career, you need to manage people intelligently. You need to be a leader. You need to speak the language of your organization, and you need to be a strategic thinker as well. Creativity comes in.
Different. I just want to build, and I really like what you just said there on strategic thinking. Just in the interest of time, Viva, can you take that up and just expand on that from your experience in terms of who a future ready lawyer is? Yeah, thank you.
Thank you very much. And literally, I agree with everything my colleagues have said. I will add just a couple of more things. Really, being a future ready lawyer is not just about technology, but it's more about what we'll call contextual intelligence. So this is the ability to operate where law, business, capital, technology, and execution meet. And to be able to do this effectively, you need commercial awareness. Obviously, you must know your client's business. And it is knowing your client's business, understanding their needs, understanding the risks attendant in their business, and understanding what it takes to execute is what gives you that complete commercial awareness. And also having a mindset shift, going from what we'll call risk avoidance as lawyers, what we do, and moving to strategic risk management. You also need to own the outcome. So not just give the clients the legal opinions, but actually have a vested interest in the solution. We must also be able to systems think. Go from just looking at manual processes to creating workflows and business processes that work and achieve the aim of giving you a legal opinion. And the minimum is tech literacy. We are in a fast-paced world. Nobody is using manual calendars anymore. Everybody's using Calendly or some other scheduling tool. Everybody is on AI. The key thing is not just the use of AI, but it's being able to take that knowledge, take your knowledge of the law, take your knowledge of the client's business, and come up with a commercially viable legal solution that achieves the client's aim. Thank you.
Thank you, panelists. I think great practical insights there. International outlook, multidisciplinary, tech savvy, be invested in your outcome. I like that contextually intelligence, Viavo. I'm going to build on what we've just heard now. So now we've got a perspective on who a future-ready lawyer is. And Leon, if I just build on what you spoke about earlier, how do you think technology and changing client expectations are disrupting the delivery of legal services? And I know you wanted to add something about the international outlook, so maybe you can throw that in as well here, just in about 2 minutes.
Yeah, I'll do my best. Yeah. Well, look, I think speed, number one, is super important now. I think in fact, let me take a step back very briefly, right? I think the idea of, the technology and the changing client expectations, which one's sort of disrupting more, they're so intertwined. I think what technology is doing is it's materially impacted on what clients expect. Firstly, I think law, there used to be a huge sort of asymmetry of information, right? So you'd have a situation where lawyers were aware of things and your layman client didn't know. Now the access to information is so huge. I mean, whether you're going to do research with ChatGPT, whether you're going to do open source research, information is not a problem getting a hold of. Understanding what something is not the challenge. I think, therefore, what clients now want from their lawyers, and one of the major impacts that I've experienced, is they want you to exercise judgment. They don't want to pay for you to kind of rehearse to them what section 1 of such and such act says. They want to know, well, actually, in your judgment, what's our best strategy here? In your experience of having worked on these matters, how do you foresee this happening? In the discussions you've had with regulators or law enforcement agencies, how does this look like it might play out for me? I don't want you to rehearse to me in a lengthy 40, 50-page legal opinion about what may or may not be the case. I want you to give me, in as succinct way as possible, clarity as to about what is the issue that I face and what is the best way for me to do that. And then I think the other major impact that technology has had, and where it's interweaves again with client expectations, is on the delivery of that advice. I think clients now want a tech augmented delivery in the way that they receive their advice from you, whether that's by utilizing AI as a tool to help do some of that labor intensive piece, whether it's using bespoke workflows that you've created to help them sort of work on their platforms, or even things like working in a Google Docs sort of environment. Clients have different needs in the way that clients want you to work how they work. I now find myself having to liaise with clients across Slack, across Telegram, across WhatsApp, across emails in the traditional sense, and I have to be agile enough to do that. They expect that. But equally, I can prepare a piece of work and I have to also now expect a client to just churn that through some sort of large language model and then come back to me and say, well, this is what ChatGPT thinks about what your advice is. Can you elaborate on these points? And so utilizing the tools and working in that environment becomes hugely important. So I think if I was to summarize it, I think the two things are they're indistinguishable in terms of the technology impact and the client expectation piece. One has really impacted on the other, and I think what we're seeing are clients becoming a lot more knowledgeable and therefore expecting a lot more sort of sharp, critical thinking from their lawyers. I think those would be my key points around that.
Thank you. I like that sharp critical thinking key nugget there. And moving on to you, Adefunke, I know I stopped you mid-sentence, but you were talking about communication, about how that's really important. So given your background in various multinational organizations, what are those legal skills that are becoming non-negotiable and which are quietly losing value. Yeah. So be good if you can continue that strand on communication. Any other insights you might want to add? Yeah.
Okay. Again, so I mentioned it earlier about commercial and financial literacy. So that's a non-negotiable for any lawyer that wants to be future ready. You should be able to interpret financial statements, understand KPIs, know the deal economics and all of that. You need to be able to effectively manage your external counsel. You need to be able to effectively manage your vendors that support you and understand the regulatory interplay and conflict of laws. Again, most companies deal on a global level now. So knowing the law in one jurisdiction is not enough. You don't have to be an expert everywhere, but you would have a team that can support you and have the basic knowledge. Cross-border regulatory navigation, again, most companies, even smaller companies now have dealings, outside of their core jurisdiction. So a future-ready lawyer must be able to manage different multi-jurisdictional laws. You must be able to understand what happens in the regulatory space. You must be able to translate legal risk to financial and operational impact. And I think that's one of the key things. So when you're advising your clients, yes, there's a legal risk, but that's not the main thing. They want to know how that can move them forward, how that can become a financial success or an operational success. Risk judgment and decision support. You need to be able to think on the spot. You need to be able to prioritize risk and know which one is higher, which ones can you go for, and which ones are a no-no. However, businesses don't want to hear you say no. When you say no outrightly, you lose their trust in you. So instead of saying no, you should find a way to do it better in a compliant way and know when to escalate. You cannot be an expert in everything. You need to rely on your cross-functional team as well. Know when it's really outside of the law or where you have the knowledge, and then rely on your team for that. Data privacy, cyber and technology law is also very important. We keep talking about AI. Every lawyer for today should understand AI governance. You don't need to understand AI, but know what you can do with AI and how that can keep you forward. Cybersecurity incident response as well. In our world, in a consumer health business that is fast-paced, dealing with consumers every day, you need to understand the cyber threat. But you shouldn't be an expert again. They are the team that actually deal with that, but know when to escalate and when to rely on them as well. You should be able to advise on digital products and platforms. Again, we see some of our products show up on Instagram, on YouTube, on TikTok, people saying they are selling our products and all of that. There's a risk to that. Connect with your marketing team, connect with your communications team, and look for how to sort of do that together. Again, stakeholder influencing skills. You're in that business to support the business to achieve its objectives. Be able to manage your stakeholders effectively. Know when to push back. Know when to say go ahead, and know how to influence them without authority. You're probably talking to senior executives, people that are at the same level with you or even higher than you. You need to be able to navigate that and let them build trust in you. Legal operations and process thinking. Again, be very fast paced. Know what is going on in your industry and how to help them. Know when to escalate issues. There's crisis and issue management, manage investigations, you deal with regulatory inquiries, reputational risk. At the back of your mind, know that your business wants you to mitigate the risk. You can't prevent everything, but it's your responsibility to be able to mitigate it and have the mitigation plans in place, and then see when it can. Finally, ESG and sustainability influence. So a lot of the big legal teams have somebody who is a specialist in ESG, and they give you the information every single day. Environment, human rights, supply chain, governance framework. You need to understand these things and the impact that they have on your organization. And you should be able to support the sustainability strategies as a future-ready lawyer.
Thank you. Wow, that's a lot of practical insights. Yeah, I'm taking notes myself here. And to you, Viava, just building on the contextual intelligence you spoke about earlier, which legacy behaviors, based on your experience building and leading a legal advisory firm, which legacy behaviors, structures, or assumptions most limit innovation in legal practice, particularly within emerging markets?
I mean, I think literally in terms of limiting structures, one of the key things that we need to be mindful of is tradition. Legal practice in Nigeria, legal practice in the UK, although they're both based on the English legal system, in Nigeria it tends to be a bit more traditional. So it's more cultural. And what people tend to do is mistake tradition or seniority for excellence and being infallible. The question now is, it's not just because you're older does not mean you know more. And ChatGPT and AI has put paid to that. And just because you know you're older and you know more as a lawyer does not mean you will have the best ideas. Because what you're finding now is people with the most innovative solutions are Gen Zs, totally different generation. They've come up with different ways of executing, and they execute much faster. I prefer to focus on the benefits of each generation as opposed to the negatives, because yes, every generation has negatives, but what you find in terms of constraints and barriers is having the traditional way of doing things will stop innovation. That will stop you from moving forward. It is essential that you have people that are adaptable. You have lawyers that are adaptable, because adaptability is pretty much the best superpower you will have. You need to be able to adapt to changing environments. You need to be able to adapt to changing technology. You need to be able to adapt to changing client needs. I tend to work with C-suite executives, business owners, and founders. And one of the, should I say, most important things I realize, apart from having business knowledge, is having an open mind and be solutions focused. They don't necessarily, as one of our speakers said, they don't necessarily want to know a 50-page opinion on what you think. What they want to know is, how does what you think affect their bottom line? And that is essential in today's reality, because if you cannot think client first, if you cannot think from the client's business first, what you will do is you will stagnate. So if you don't innovate, you will stagnate. And if you stagnate, your business will die. So what we need to be thinking about is understanding that with traditional systems, innovation is key. And we cannot afford to do things the way they were done even 5 years ago, because business has moved on, technology has moved on, legal practice has moved on, and the law has moved on. Thank you.
Thank you. Adaptability in innovation is key. So we're running slightly late. So what I will try and do is, if we can wrap up the last question, I want sort of 30-second summary in terms of your takeaway so that we can open this for a few questions. So for our audience who's joining us, to raise your question, please, if you can add it to the Q&A link, which should be at the bottom of your screen, ready for our panelists to answer. So please do add your Q&A questions, your questions to the Q&A tab at the bottom of your Zoom panel. So Leon, we've heard really interesting insights from you, tech savvy, international outlook. Again, this is in the context of who is a future ready lawyer, speed, delivery of advice. If you were to wrap up in a few minutes, in a minute, what capabilities do you think, out of all of these practical insights you shared, should be prioritized by lawyers to help them future-proof their practices?
Yeah, no. So look, I think tech literacy, tech savvy, whichever way you want to spin it, that's super important. And I chime with what my fellow panelists have said, so I won't repeat it, but it's just that appreciation of what technology is coming, being aware of things and actively trying to incorporate them. For me, really focusing on those non-legal skills is important. So I think Adefunke mentioned understanding things like your client's bottom line, understanding basic financials, understanding business language, MVP, value propositions, all of these sorts of terminology and concepts are super important. And exactly as Viavo said, it's important that you speak the language that your client speaks so that you resonate with them and you can deliver the advice that they need. Another thing Viavo said, which I think I want to add, is that cultural piece. I think in terms of sort of the characteristics that you need to have an organization that has a whole cultural reset around where the focus needs to be. So I've worked in firms what were ahead of the curve and actually employed ahead of innovation, actually invested time in ensuring that legal associates were thinking about the non-legal issues, working with the innovation team to roll out services and products that might help their particular practice areas. I think all of these skills and sort of this mindset is super important for anybody, for all lawyers now, and especially those that want to ensure that they future-proof their practice.
I like that. Tech literacy, tech savvy, cultural reset. And I do think, given the various practical insights you shared, I think throughout the conversation, you talked about really translatable advice, risk tolerance, understanding the business model, really immersing yourself in the client's business. What does the client want? What do they want to achieve? If you were to sum this up, what is that mindset, single mindset, or even mindset shifts that lawyers should make to remain those trusted advisors within organizations like yourself, your organization?
So for lawyers to be trusted advisors, they're working in complex global organizations, so that has to be at the back of their minds every time. We need to stop defining our value primarily by having the legal answer to everything. You don't have an answer to everything, so speak up when you have to, seek help when you have to, but your focus should be more on shaping the context in which decisions are made and supporting your business to achieve its objectives. If they fail, you don't even have a salary. We need to be very business centric, know our clients, know our industry, and be an enabler than somebody that is a stumbling block. And in conclusion, a future ready lawyer's role is not to be the organization's legal conscience alone, but should be a strategic thinker and a strategic sense maker. So in every advice that you give your client, make sure that it makes commercial sense and you add value to everything that they have to do. That would just make you indispensable by that organization and move the way they are moving because it's a fast-paced world.
Thank you. So key to really honing and support your business. And Viavo, if you were to sum up, given the advice you shared about adaptability, innovation, contextual intelligence, knowing your clients, what is that one practical change, for instance, the Nigerian law firms can implement now to better prepare for the future of legal practice?
I think the biggest thing is really adaptability. We'll take it as read that everybody has legal knowledge. You must be able to adapt to everything, and adaptability is probably the easiest way to describe what we're talking about, because adaptability covers everything we've spoken about. It covers your mindsets. It covers being willing to innovate. It covers understanding your client's needs, and it covers being able to execute. At its most basic, legal work, what we do in terms of giving opinions is legal work. Where we need to operate is legal strategy. Where you're advising clients about what is coming up and what the implications are for their business. It's being future ready, preemptive rather than reactive. And I think understanding that, coupled with what everybody else has said in terms of being tech savvy, business, and understanding the client's needs, is what you need to be ready for the future. And that's what we do at Blackstone Legal Advisory. Thank you.
Thank you, panelists. Just going to check the Q&A. Whilst I'm doing that, I just want to summarize. I think you've heard it all, distinguished colleagues and guests. Tech savvy, adaptability, contextual intelligence, where the intersection of law, business, and tech meet. I like that. I will appropriate that legally. And the ability to think on the spot, and you're not the knowledge, you don't have the answer for everything. You're there to understand the business needs and how you support them. So I just want to say thank you very much to our extraordinary panelists for your honest reflections, for your insights. I could talk all day about this, but we have another panel session going to start off soon. But before we do that, I might have a couple questions. I'm just looking through the chat. So the first one I have is, as an in-house lawyer, a big challenge I've had has been communicating with colleagues who have very little legal knowledge but strong opinions. How have you all overcome this? So if I may start with Adefunke, just quick nuggets, how would you deal with this situation? Yeah.
That's a very relative question. So it's what we live by every day. When you go in-house, also if I look back at when I started my in-house career, I was 5 years post-school. I was joining a media and entertainment company that had never had a lawyer work with them. It was a creative industry. This was in 2009. It was a family-owned business and they did what they liked. So first, it was a female that was young, that was coming to poke her nose in everything. And then I had to be very strong. You have to leave emotions aside. You have to be very strong and make sure that you give sound legal advice and then you stand firm in your opinion. And that's where you learn about emotional intelligence. So the first thing is know your onions, understand the industry, know the law. You're not there to play or be anybody's friends. Yes, you would have enemies on the way, but you have to just do what you have to do and be firm to say no when you have to say no. When it comes to the work, you have to look at the risk, you have to look at the objectives and say no. But the higher you get, then you become a bit subtle in how you deal with things. When you get to a multinational, it's a different ballgame. Your manager sort of controls your career indirectly. People don't want a lawyer that comes to control them or tell them what to do. So you just have to break it down, speak their language, break it down the best way, and then scare them with, if you don't do it this way, everything can come crashing down. The only way you can make an influence is if you've built their trust over time. So they know that when you tell them it's a goal, then it is a goal. They know they don't have to go back to their external counsel to verify or check the advice that you've given them. Get support from your external counsel, get support from your regulatory team. Do your homework before you go to any meeting and learn when to push back. So they invite a lawyer to every single meeting. Look at the agenda, ask questions of what do you want to talk about. If it's completely a waste of time for you, tell them you're not going to add any valuable thing to that meeting and say no. But when they come to you, be ready with an advice, but be firm. You have to sort of develop the firmness, but also be a bit emotionally intelligent to be able to, communicate with them effectively. But for me, what has worked importantly for me is I've been able to build trust to tell them that you're an expert in this field and whatever advice you give to them is a sound advice and it does help in the relationship. Yeah.
Thank you so much, Adefunke. I have only time for two really quick questions because we have to move to the next panel. So the next one, if I may, maybe Viava, if you can take this, how should African lawyers approach legal technology adoption given infrastructure and regulatory realities? So really brief key nuggets here. And we will come back to, just for the benefit of our audience, if we can't take your question, we'll endeavor to come back with answers after the webinar. Yeah. So over to you,
Okay.
Viava.
Thank you. In terms of the approach, I would say full on. And what I mean by that is have an open mind, adopt quickly because technology moves fast. Law plays catch up afterwards. But I think mentally, we must understand it from a conceptual perspective. And in terms of understanding it from a conceptual perspective, it's also understanding that those are tools to make our work easier. You have things like Calendly that helps you with scheduling. You have definitely that helps you with drafting. You have Law Pavilion that aids you in your drafting and your research. What those do is they make you more effective. We cannot afford to stay stuck in the past. We must be ready to adapt and innovate. So I suppose the most important thing is have an open mind and be ready to utilize the tools for what benefits they can bring. Because bottom line, we're there to serve our clients. And serving your client means being in the best position to be able to offer the best legal solutions to their problems.
Thank you so much, Fiavo. And I think building on that, I'd like to open this up to you, Leon. Really quick question. Which technologies, given your extensive experience in fintech digital assets, do you believe every lawyer should understand at a conceptual level, even if they never become technical experts? So there's probably a build on Viavo's points, yeah.
Yeah, no, absolutely. Look, I think the biggest sort of development over the last 10, 15 years is the importance of data, information, especially as we move into a digital age. And the two principal technologies around data and digital information are blockchain, which is essentially a huge database that holds data, and AI, which is the best tool to analyze and manipulate and deal with data. So given the direction of travel where we are in the world today, in terms of sort of the digital enterprises that we're seeing building up, the shift to kind of less real world assets and more tokenized assets, I think having a full appreciation of blockchain, or at least a conceptual appreciation of blockchain and a conceptual understanding of AI and what it, and especially that the relationship between the two, I think will stand you in good stead, because I think that's where the future is. We won't be too far away from seeing lots of contracts being automatically executed between AI bots on a blockchain using data that's provided by a company. So, you know, being aware of them from now will at least put you in a good position to ensure you're able to advise and be at the forefront of those issues.
Thank you so much, Leon, and thank you to all our panelists. I will now hand over and thank you for your insights. If we can't answer your question now, as I said, we will endeavour to come back to you with answers from our panelists after this. And with that said, I will hand over back to my colleague, Toyin Asada, to guide us through the next panel session. Thank you, panelists. Thank you. Over to you, Toyin.
Thank you.
All right. Thank you so much, Genevieve, for an excellent moderation. And very many thanks to our incredible panelists of the first session. They've done great justice to the question, to the topic, the future-ready lawyer. And I feel like that's a great way to have started today's webinar. And I believe that from what they've shared with us, talking about things like innovation, talking about contextual intelligence. I love it so much because it's so, it's a unique concept that we need to really explore. What Viavo said about going beyond technology to contextual intelligence. And speaking of which, that is what has led us to the next session we are into now, basically. And we have our stellar speakers here on board, ready to do justice to it. So this session is a deep dive, basically, into the meat of this matter. We've spoken about the future, right? So now it's time to talk about how to design the future and not react to it. So the topic of this panel session is technology, AI, and cross-border collaboration, designing the future and not reacting to it. And the purpose for this panel is to explore how lawyers can intentionally design ethical, technology-enabled UK-Nigerian collaboration rather than passively adapt to tools shaped by others. The goal here is for all of us on this webinar to gain practical insights on how technology and AI can be used deliberately, intentionally, and responsibly to enhance our legal practice and cross-border legal collaboration. We've established before now from the various speakers, and I mentioned earlier as well, how AI is shaping our work and even cross-border transactions. So what are the practical insights we can gain? And how can we better prepare ourselves for this? How can we not just be consumers, but also be able to be a part of the designing So like co-designers of AI and technology, and also how can it be context-based? So when it comes to things like ethical standards, they don't just force it on us. How do we also prepare ourselves and be intentional basically in our use of AI? And the good thing about this panel is the fact that we have panelists who are ready to give us practical answers beyond just the theory. They're going to give us practical examples, practical answers, and actionable points that we can use. Somebody asked a question earlier in the last session about what AI tools can lawyers use. You're in the right place because two of our speakers are innovators who have, technology, have software, they have products that they can, recommend to us, that can be useful for our practice. And the goal is not just to just talk, but basically practical insight. So without further ado, I'm going to introduce each of our speakers before we go into the questions proper. So the very first speaker I'll be introducing is Stephen Dowling, who is the founder of TrialView. So Stephen is the CEO and founder of TrialView, an award-winning AI platform designed to streamline dispute resolution processes. And Stephen is also a practicing senior counsel in Ireland with over 20 years of experience in commercial and civil litigation. Another unique thing about this panel is the fact that each speaker will be addressing this topic from various, angles, various perspectives. Stephen here will be handling this session's questions from the disputes perspective. So our next speaker is Fernandez Marcos Obiene. Fernandez is currently the Special Assistant to the President of Nigeria on justice sector reform and ICT, digital and innovative technology. He's also the founder of Justice Tech NG Hackathon and Accelerator with a background in tech, innovation, and policy. He's also a former partner as Sedaka Attorneys. I also know that Fernandez is an author and he has a book on, on tech for lawyers, basically. And Fernandez will be handling the question from the perspective of regulation and policy. Our next speaker is Nkem Dilim Beho. She is the CEO of Future Software Resources Limited and co-founder of AdCollab Africa. Since 2008, she has led Future Software Resources Limited, rebranding it into one of Nigeria's leading digital agencies. And the firm has served over 200 clients and trained more than 1,500 executives in digital literacy. With regards to policy and advisory, she's also the chair of the Digital Economy Policy Commission at the Nigerian Economic Summit Group, NESG, and a member of the Lagos State Science, Research and Innovation Council. With regards to social impact, she's co-founded ESG in Action Africa, a consultancy focused on environmental, social, and governance principles. So I'm sure you can tell that our speakers are more than able to take on this conversation, and Nkem Dilim will be, speaking from this perspective of digital strategy and tech for lawyers and in legal practice. So welcome our dear speakers and thank you for joining us. So let's start with Stephen. From a dispute standpoint, what intentional steps can lawyers and law firms take with regards to incorporating technology and AI in their practices and also in cross-border transactions between Nigeria and the UK?
Hi, Toyin. Thank you very much for inviting me along today. I'm delighted to be here, and thank you to the BNLF and the NBA and SPL and SLP for inviting me along. So I just probably maybe set the scene from my perspective as to the role that technology is going to play and the steps that need to be taken by lawyers when they're looking at this. My background is I'm a disputes lawyer, so I'm essentially a commercial barrister. And my entire career prior to moving into technology was essentially around two things. One was around advising clients in relation to the disputes they were in and providing the best advice possible. But the second part of my job was to essentially advocate on their behalf. And they're actually two quite different jobs. They are, one involves understanding your client's needs very well understanding the challenges they face in any particular dispute, and being able to provide the most practical advice possible. The second part of that is completely different. It's not about understanding your client as such, it's about essentially making the best case you can possibly make, representing your client's interests in court, and being as persuasive as possible with respect to the decision maker. And when it comes to the use of technology, it's my view that technology is going to radically change both aspects of that particular job. Firstly, and almost kind of more importantly than the advocacy piece, it's the advisory piece when it comes to disputes. So my background, whenever I was asked as a lawyer to provide advices to clients on any particular matter, the starting point from the client's perspective is always going to be around the merits of the particular piece of litigation that they're involved in. And it always begins with that. The core piece of advice is, well, what am I looking at here in terms of my exposure and my risk? Do I have a case or do I not have a case? And if I have a case, what's the consequence of that? If I don't have a case, what's the consequence of that? And whilst we're actually, as lawyers, relatively inexperienced lawyers, we should be in a good position to articulate things like how long the case might take, the procedural path the lawyer has to go down, the likely consequences of failure or success at a large level. That's actually quite easy stuff, in my view, to articulate. That's kind of standard. What's actually far more difficult is to provide a crystal ball into what the dispute is, how the dispute will unfold in terms of its merits. And one of the things I think which is traditionally very frustrating for clients is the inability of counsel or lawyers to nail their colors to the mast. They'll always hedge. They'll always say, well, if the facts turn out this way, then the result will be that. And they turn out, if the witness gives evidence in a different way, the decision will be different. And I think from a disputes perspective, that's very frustrating for clients. And they know that when lawyers give that advice, essentially it's just a hedge, and it's very, very hard to get a really good insight into what the likely outcome is going to be. I think what's going to change is the ability of disputes lawyers to provide a far more certain or far more probative assessment of the litigation outcome in the near future. And the reason I say that is because the technology has got to a point where in any particular dispute, what you will have, particularly in either international disputes or in commercial disputes, what you will have is a body of evidence and documentation which the client will have available to them. Because most of the interactions that involve the dispute, be it an employment issue, be it an international contract, be it a piece of infrastructure or construction issue, there's going to be a whole body of evidence that they will have available to them there and then. And the investigative part of being a disputes lawyer is going to be radically transformed by technology. So, for example, at TrialView, one of the key reasons we set up TrialView was the challenge of managing massive volumes of documentation and be able to interrogate that. And we're now at a point with AI where we can literally interrogate hundreds of thousands, tens of thousands, hundreds of thousands of documents in a timescale which would have been unfathomable only 2 years ago. And most importantly, those documents can be interrogated for the purpose of really trying to find out, in fact, what is the factual matrix that underpins this particular dispute? What are the parameters? And that completely then will transform the analysis, because for the first time, you'll be able to provide clients, if you have the right technology, with very well-informed analysis based on the factual matrix of the decision. So in my view, as a disputes lawyer, taking the idea of let's be intentional about technology, we need to focus on where is the trend going. And one of the big trends that we're seeing is that there's an explosion of documentary evidence. There's AI tools out there that can allow you to analyze that. And what's going to happen, I think, is in the disputes world, the lawyers who are able to take advantage of the explosion of documentation, use the right tools to interrogate that in order to provide better advices to their clients at a much earlier stage in the litigation, will win, because they will be able to provide excellent advice at a much earlier stage, which is of huge value to clients, particularly to in-house. I know there's a lot of in-house lawyers here today who can find out at an early stage, where is this going to go? And if you can give that advice at a much earlier stage, that's, I think, of huge value. And I think that then sets up everything else thereafter, because once in a disputes context, once you are on top of the factual matrix, then at every step of the way, you're able to perform your job much more efficiently. You'll be able to draft the pleadings, you'll be able to draft witness statements, you'll be able to interrogate the documentation, you'll be able to conduct discovery much more efficiently, and therefore provide your client with a better service. So what I'm really saying is, in a disputes context, evidence is everything, and having the right tools to interrogate that evidence, I think, is going to be critical.
Thank you so much, Stephen. Documentation is very important, it's very key. So in incorporating technology, dispute lawyers in the house, I hope you're taking notes. So now let's move to Fernandez. Let him talk to us about the regulatory standpoint of incorporating AI and technology to legal practices. Fernandez, please talk to us more about that. How can we as lawyers in our legal practices and also in cross-border transactions, what are the regulatory and policy considerations when it comes to incorporating AI and technology into what we do?
Thank you very much. I mean, I've listened to what Stephen is saying, and I was wondering, is that something that I'm going to add to this conversation again? Stephen is saying everything. But I'm going to try and say something. I used to tell people at events that one of the reasons why I like to speak last at events is so that I've heard what the other people have said, and I will just make 1 or 2 points, and it will seem like I know what I'm saying, even though I don't know as much. Anyway, I'm going to look at it from 2 perspectives. I'm going to talk about it from the point of bar associations, because we're talking about regulations, and from the point of law firms and organizations themselves that use the technology. I mean, from the perspective of law firms, and I'm going to try to be quick with it. From the perspective of bar associations, I mean, we've seen the Chinese arbitrators, they have guidelines for use of AI. I think I saw it, was released last year. The IBA also released something for artificial intelligence in artificial intelligence for mediation. Yes, and so we're seeing that the Nigerian Bar Association also did something like that through the SLP. We had released regulations for the use of artificial intelligence in legal practice. And the intention of documents like that is really to see how we can ensure that our use of artificial intelligence is not just that we're not just seeing it and using it, but that we're using it, we're following some guidelines, we're ensuring that we have the proper procedures, we're using proper data protection guidelines, etc., and we're ensuring that we're not just essentially just don't waste people's time. So from an association's point of view, it's important that we not just have these documents, but also try to enforce it, impress it on others. To say, okay, this is what needs to be done. We need to ensure that we get adequate publicity from all of us. Everybody's looking at it, talking about it, ensure that the conversation goes. And then we don't just need to have policies for the point of having policies or guidelines just from the we have to have things that actually affect. So even when we have high-level policies, it's important that we break them down, to minor use cases and show people how they can apply this to specific cases, etc. Otherwise, you're not able to compete. And then from the law firm or individual organization point of view, I'm going to look at it from, there was a survey that was done by, I think, the IBA Young Lawyers Forum, and they talked about it last year at the IBA conference, and they said that when they surveyed, it turned out that the older lawyers tended to indicate that they wanted to use AI more than the younger persons. One reason for it could be that the older lawyers have the free in terms of their decision makers, right? So they'll be able to say, I want to use it. But for the younger lawyers, if there are no guidance in the firm, there's no guidance in those organizations, you find that maybe they are afraid to use it. So because they're afraid to use it, they would not ordinarily indicate in the form that they're going to use it. So it's important that at law firm stage, at the stage of your law firm or any other organization that uses it, where actively, I mean, it's very important that you first have a policy, and not just for, I know that Kim Dillim is going to talk about a number of other things relating to it, and I'm going to leave that part to her. But it's important that we have these policies that tell us, okay, this is how we can use it, this is what we can use this for, this is the extent that we can use it, this is the kind of information that we can put in it, and you have to make it spell it down so that even the people at the bottom, everybody in the firm knows his responsibility, knows what kind of things to use, and his responsibility generally. Then, from the point of view of, and I think I mentioned this somewhere last year, you find that because AI is becoming so good, a lot of our work that we do that would have ordinarily given a younger lawyer to do, we would not give him to do because I can sit down in my office and do it in 5 minutes, right? Why would I give it to him to take 2 days to do it and then come back to me and then I'll still review the same thing? So it's important that in doing these policies, we're also looking at the future because we can't be talking about international practice if we don't have a practice for the future. So we also have to find a way to incorporate trainings and ensure that again these policies work on the younger people, the people that are going to practice that law tomorrow. You know, and it's difficult to do because I'm sitting down here. Most of my work, I mean not most, but a lot of my work, rather than if I have the time, rather than do it, rather than give to somebody, I will start there, then I'll review it. I can spend hours reviewing, but I'm comfortable because it's much easier to review work than to start it afresh, even though it's not very well written. But as long as it's something standard, it's easier to review than to write afresh. So you find that these people are not. And then from the perspective of the younger persons, again, because you have to be future ready, because you are the future. It's important that even if your law firm hasn't given you an opportunity to say use this, it's important that you take the initiative. Okay, can I use this? Can I take this? What kind of AI can we use? Go and ask them so that you get permission upfront rather than waiting for them to bring that information to you. And then you must also master how it is used before you're using it in the sense that, I mean, if you don't use it well, you won't get the right answers. You won't get the right responses. If you're not getting the right responses, well, you'll not get good work. So your boss will spend maybe after giving you work 3 or 4 times, you'll get tired and say, you know what, I'll do it by myself. And I'll start it by myself and I'll get it done by myself. So it's important that you master the use. You already understand what the law is, you master how to use it. So both of them complement. And so as they're giving you that work.
Thank you so much, Fernandez. I think I would have to just cut you a bit and we'll get back to you briefly.
Hello, is that?
So that we can weigh in on this topic as well for the sake of time. I don't know if you can hear me, Fernandez.
I can hear you.
Okay, so please just give us a minute. We'll circle back. I love what you're talking about from the the older lawyers and the younger lawyers' perspective, which bring in their strengths. So they're the young ones bringing initiatives, right? So speaking of initiatives, recommending tools and stuff, this is where Ikemjidin comes in. Based on your experience, Ma, please can you share with us digital strategies that we can actually use? So I know there are a lot of young lawyers, and even for the older lawyers, or let's say the mid-level lawyers, on tools that we can use to intentionally, prepare ourselves with regards to technology and AI.
All right, thank you very much, Toyin. So I think the first misconception is that you jump right into tools, right? So AI adoption really shouldn't start with tools. It should start with intent. And what we're seeing, and this is not just in the legal field, but across board, is that a lot of clients of ours, they jump right into experimenting. So they get AI tools and they're like super excited about it. Or they build pilots and are investing a lot of money without really thinking through what is the picture of success, without really thinking through what is my desired return on investment, how much is this actually going to cost at scale. So this is a pretty big problem because it means that you are adopting a new technology without actually looking at some of the things that you need to really look at, which is how does this tie into my actual business strategy? How does this generate more revenue? How does this actually create value for us internally as well as externally for our clients? So where should you be starting? So you should be starting with really thinking through, what do we actually want to achieve with this? Look at your workflows, whether it's research or drafting documents, compliance of any kind of cross-border coordination, and thinking through where can AI remove friction. But before you even go into, sort of solutioning, really think through what data do you actually have available? What format is that data? What quality is that data? Then also think about, do you have the governance structures to support this, right? Fernandez talked about people using AI without actually having the right policies to support it internally, right? So start with drafting an AI use policy, right? Because one of the biggest threats that we see today is actually shadow AI, which basically means this is AI being used in organizations without official authorization and without any guardrails, without any policies supporting it, right? So this is an employee who thinks he's smart or she's smart, plugs, a legal case into AI. And in that moment, all that information becomes public, right? So if it's not a really, sort of controlled environment, it's very, very dangerous for people who work in professional services and are bound by confidentiality to actually use AI, right? So that's one. I think the second thing really is around education of leadership. If your partners and senior lawyers don't really understand what AI can do and cannot do or should not do, adoption becomes really fragmented and reactive. So AI literacy is really important at that leadership level. And then, sort of further down. So AI strategy is formulated at board level as well as C-level, executive or partner level in your case. And those people need to actually understand what does that entail? What do we need to put into an AI strategy, right? And we've actually developed an organizational AI training playbook, which I can also share, that guides leaders, to just really think through what do we need to do from a training perspective. And you need to lead with governance, right? If you sort of bring in governance later, you are already, sort of going to deal with a really, really big mess. So be really, really clear around what are the guardrails that we're going to set up around data ownership, data privacy, confidentiality, auditability of our AI, accountability, cross-border risk. So sometimes we use AI because we think that, oh, it's going to make life easier, right? And there's a really good example. There's a note taker company that was very popular. I'm not going to name names. And, the AI started plugging itself into all the meetings in the company and started sending the minutes to everybody in the entire database, right? So obviously it wasn't supposed to do that. It wasn't supposed to be in all the meetings. It wasn't supposed to send the email. So sometimes, because a lot of these tools are also still in development, you actually don't know what they're doing, right? And you find out retrospectively. We've also had, cyber issues when you think about Claude, right? So Claude is Anthropic's LLM and, a very, very powerful tool similar to ChatGPT and Manus and DeepSeek. And it was actually hacked through an AI pretending to do vulnerability scans, right? And when it hacked Claude, it wasn't hacking Claude, it was hacking enterprise clients of Claude, right? And there were over 20,000 clients that were compromised, right? And they had enterprise AI solutions. So there's that security layer as well that you need to think about. So there's a lot of different, sort of points that you really need to think about before you even start using the tools, because this is not normal technology, right? This is not Excel. This is not PowerPoint. This is not Salesforce. This is much more powerful, and it expands really the surface of attackability. It expands the surface of data leakages. And there are so many examples of this. At Samsung, for example, one of the developers uploaded the entire GitHub code base into ChatGPT because he was trying to debug it. He didn't really quite understand that doing that made that entire proprietary code public, right? And this wiped out $200 million of Samsung stock. So the implications are really massive. So I think when we're approaching AI, we really need to be very careful because there are massive, massive risks associated with it, right? And we've also created this board AI readiness charter that basically really outlines what boards and C-level executives need to be thinking through when they are navigating AI adoption and what the different steps are. And I think once you've actually put those foundations in place, then AI can be a really, really big enabler and not a risk. But you do have to be very careful. Thank you.
Thank you. Thank you so much, Nkendilin. That was so insightful. I like the fact that you put a lot of practical realities to the conversation. So it's not enough to just incorporate AI for the fun of it. Oh, the world is evolving, let's just take in AI. But we need to be intentional. Like my question was is about, does this serve us? Can we afford this? How can we use this? And then are we aware of the risks that come with using this particular tool? So thank you so much for that. So speaking of risk, I think that is where regulation comes in. So I'm going to circle back to Fernandez, who doesn't like being the first to answer. Interestingly, yeah. So I want you, Fernandez, I want you to please talk to us about the current regulatory strategy so that we brought you on board in Nigeria having AI. I know there are debates about whether or not it's there or if it's enough, but I want you to talk to us about the current regulations available in Nigeria, regarding technology and AI and legal practices, and if they are enabling this intentionality and they are constraining it. In just 2 minutes max, because we're pressed for time, we're really blessed for it.
2 minutes. What can I say in 2 minutes?
As much as we can.
Okay. I mean, everybody knows the Nigeria Data Protection Act. And that's our most significant rule that talks about data protection. It doesn't necessarily cover everything AI, but it talks about decision making using autonomous machines decisions. It talks about how you can share data, what processes you should use. I mean, that's a significant one because it mirrors to a large extent the UK GDPR, um, which it talks about similar things. So for us, it's sort of a way that both countries can actually deal with each other with some level of confidence. And I say some level of confidence because there are different mechanisms for enforcement in both places. There are enforcement gaps in both places. I don't want to mention this thing. Then the second thing, of course, is like I mentioned earlier, regulation by, I mean, there are a number of them, they are sector related. We also have the artificial intelligence policy, which we developed as a government, enacted last year. Then at the Nigerian Bar Association, we've talked about the uh, guidelines for the use of. I mean, again, these guidelines are not just. It's not just artificial intelligence. So we have actually 4 guidelines. We have guidelines for the use of artificial intelligence. We have data protection guidelines. We have guidelines for the use of technology generally, and then there's the cybersecurity guidelines, which was launched by the NBA. I'm informed that recently the NBA is sort of trying to do a harmonization and try to see at the NBA at the national level. This is not just the SLP. Also trying to see how we can put those documents together and ensure that we can have something that we can use across board. Even at the SLP level too, there's something similar to we're looking at those documents and see how we can shrink them to sort of size where everybody can just take it without having to read a lengthy document because as it is, the documents are quite lengthy. So you said 2 minutes. I wanted to say something else, but
I would go
I'm
back
it
to
is
you,
too much.
but I like, how I made you round up, talking about lengthy documents. So speaking of lengthy documents, I think that is the solution that trial view is bringing, to bear for lawyers, right, Stephen? So yes, I'm coming back to you with our next question, which is, so how is technology, especially AI, shaping cross-border disputes between UK and Nigeria? From your experience as a dispute lawyer, can you just quickly, in 2 minutes as well, just talk to us about how it's shaping it,
Yeah.
cross-border disputes?
Don't give him 2 minutes, I'll be offended.
So very briefly, Toyan, what we're seeing in terms of how it's shaping the cross-border disputes is it's creating an equality of arms that wasn't there previously. So a good example of this is we work, for example, with firms like Quinn Emanuel, and we've done a case study on a particular case where they actually, in a particular matter, had a small legal team devoted to a case against a much larger legal team, and they used TrialView to manage the documentation and act as like another part of that legal team, a person, a kind of an agent able to find relevant material, summarize documentation, find issues in the documents and evidence that supported those issues. And in that case study, it's quite clear they were successful in defending what was a very, very large claim. And with a smaller legal team, they were actually able to win a very, very large legal case. And I think in the context of cross-border disputes, in the context of having clients who have deep pockets and clients who don't have such deep pockets, AI does provide the possibility of creating an equality of arms where you can, if you're an effective litigator, use these tools to actually represent your clients in as effective way as maybe a large law firm, for example. And that provides two opportunities. One, it enables the smaller firms and the smaller clients to take on the larger players and to compete at the highest level. But secondly, it also allows other business models to emerge where a firm can take on more cases, can actually do more with less, and that means essentially can get a massive return on investment on the use of AI. So that's just a simple example, I think, of where we're going to see AI affecting potentially cross-border disputes, where you often get those disparities between resources and on litigants on both sides.
Thank you so much, Stephen. Thanks for that practical example. So that way it liberates people from thinking I'm too small to handle cross-border disputes or whatever, because there are tools that enable you to know how to use them effectively, right? Yes. So, Kendlin, back to you. So, can you talk to us about, with regards to UK-Nigeria collaborations? We know that most AI infrastructure now sits outside Africa, but how do Nigerian firms avoid being structurally dependent? So you also talked about how your products, future softs, can be helpful in this regard, so that firms in Nigeria are not wholly dependent on AI infrastructure outside the country.
All right, thank you so much. So I think that the important question around dependencies isn't really about geography, right? It's about control, because this is a question that you have everywhere in the world. And the real risk is not that the infrastructure sits out of Africa, it's that a lot of people actually don't understand the systems that they're using, right? And don't have control over the data, don't have the internal capability to actually make these informed decisions. So you really need to think about capability ownership, right? How do you build capability internally that really understands the solutions that you're using, that understands where the data sits, right? That understands how to actually engage with vendors, what the really big risks are that they should be looking out for from a sovereignty perspective. Secondly, it's really about being intentional about data sovereignty. And when you think about, regulated industry like financial services, data sovereignty is a big deal, which means that there have to be data centers on ground that also are, hold that data. And there are different types of models that can be used, like RAG models, which is basically retrieval augmented generation, that allows the data to sit in your data center or on-prem, and where it's almost like you go to a library and you can read a book, but you can't take the book away and keep it, right? So the AI is able to access the data, read the data, but it doesn't own the data. So those are some of the things that can be put in place. What we're also seeing today, there was actually just an announcement that one of the data center providers is launching an AI data center in Nigeria, and this will be the first. And I think this is really exciting and really great news for building AI infrastructure locally, right? And I think that a lot of the regulation will go along those lines to actually push for adoption of local data centers that are AI enabled. So at AI Collab, we actually spend a lot of time helping organizations really move from curiosity to confidence. And we don't sell tools. We start with readiness and really understanding where you are from a strategy, data, skills, and structure and risk perspective. And we have an AI readiness questionnaire, which I can also share. And we would like to also invite, all the different firms on this call to take some time to actually fill this readiness questionnaire. And they would then receive a high-level readiness assessment that would help them a little bit more in terms of where they actually are. And allows them to then, kind of build a strategy. So what we do at AI Collab is really to help you walk that walk, from exploring use cases to designing your strategy to helping you with the actual implementation. We're, partnered with a lot of different AI solutions providers, as well as a lot of different AI experts. And we're actually trying to build the, sort of biggest African AI expert community on the continent. So I think the objective is not to, sort of reject global AI platforms, but to engage with them intelligently, right? And really to be clear on what your position is, so that you don't have that dependency, right? So I think you need to understand it in order to have the, sort of upper hand. Thank you.
Thank you so much, Akindele. And a lot of these resources have been mentioned. I'm sure the NBA is going to communicate it to everyone on this call. A lot of these links are in our chat box, and we'll find a way to transport it to the general Q&A box so that people can have access to these links because they're very important. So thank you, Fernandez. Thank you, Nkandile, for posting these resources, the links to the resources in the chat box. So we'll make sure that, everyone can have access to it on the chat box so that you can, click on them, download them, and start using them. The essence of this is not just a talk shop, it's for us to actually implement these things. And we are grateful that our speakers are giving us these platforms in real time. And even the NBA as well has also, we've posted this playbook, the readiness charter link, everything. So please, let's ensure that we are making use of it. So we are really pressed for time. So we're going to go to Q&A, but before we do so, if you have questions, put them in the chat box. We'll try and attend maybe one or two, within the limited time that we have. We're literally on borrowed time now. Let's try and round up with just one last question for each of our panelists. And I want us to please answer this as quickly as possible in less than a minute. So, Stephen, are you there, Stephen? In conclusion, where do we draw the line? We've said us a lot of good things about AI, what it can do for us, our practices, cross-border disputes, everything. But where do we draw the line on decisions that AI can make and what it cannot make?
In my personal view, you need to draw AI a line where you need to bring in your own experience and skills. So think of AI, in my view, as brilliant as a junior associate at reading and gathering information, finding material that allows then you as the decision maker to make the analysis. So I think leave the analysis to the lawyers, leave the strategy to the lawyers, leave the skill sets about emotional intelligence, how to persuade the judge, how to advise your client. Leave that to the lawyers and do what lawyers do best, which is basically provide good advice and strategy. And then leave AI to do the work of finding the information that you need to make the best decisions possible. And that's, I think, its skill set. And I think that for me is a very simple line. Let AI find the right information to allow you make the right decision.
I love this. Let AI find the right information so you can make the right decision. So it becomes a win-win situation. So over to you, Fernandez. Where do you draw the line in a minute?
Why don't you allow me to go last now? I think Kevin want to say something.
I think I'm doing it intentionally. The more you say I want to go last, the more I want to just put you forward. Yeah.
Well, I'm going to go a bit further than Stephen. While the decision making is always and should always be of the lawyers, I think everything else, now when I say decision making, I mean deciding I'm going to leave this paragraph, I'm going to use this paragraph. Every statement, I mean, I don't think there's a problem in having, do a first draft, do a second draft, but any statement that goes out there on that document should be yours. You have read it, you agree with it. If there's a comment that you did not previously, you have researched it after the opinion has been made, you agree with it, and then you are saying this is mine. So I'm saying every single word. Sometimes you use a word that is not supposed to be used. So even if you agree with the statement, the word itself, you're not sure you understand it, make sure you understand every single thing and agree. Every single thing. That's the point of the human individual. I mean, I don't have a problem with, AI can do the research. It can even go beyond doing the research or putting documents together. And even that, because I know that we have a technology now for the judiciary that helps write first draft of judgments. So it can actually even not judgments, but opinions so that the judges can put it together and make them judgments. So they have actually done the writing. So you've written, you've done, but before it goes out, before it leaves your table, before it leaves this thing, you have read everything that's there, you have researched as appropriate, you agree with every statement that's made, and then you sign off. that's why I say I draw the line. I mean, I don't care what else. Anything you want to use AI to do, use it. If you want to use it to create a frying pan, if you want to use it to run your firm, and but the final decision making before it moves from your area of authority to the next person, even within the firm. So I have done work. I use AI to do the work. Before I send it to whoever, I agree with that comment. You take it to the next person. That person, even whether or not the person is using AI, the person has to have read, research, and agree with all that point before it takes it to the next person. It doesn't have to be all the way this thing. Again, of course, with the appropriate, security so that certain information don't go out. Now, I assume we've dealt with that already. We dealt with security, data protection, and all those issues. I'm talking of in terms of reasoning and decision making. Before it leaves my table, before it gets to Kim Denim's table, before it gets to Stephen's table, I read it, I have agreed with it, I've looked at it over and over again. I know it's mine. I can defend it. If somebody says something, I cannot say, oh, because I read recently, last year or 2 years ago, the judgment of I think, I don't want to mention the courts that I don't embarrass, but I read the judgment of the court that was written using certain authorities that were not already existing. Before now, it was only council. Now we're getting a situation where it gets into the court. So, and then, of course, when you say, oh, they will give an excuse that, oh, so person gave me the authority.
Fernanda, you've actually taken like 3 minutes thereabouts. Thank you so much.
Okay, thank you.
And so, you've really explored this topic, and I hope that everybody is taking notes and learning. Because of this your time, let's just really want to came to for our own, will I say, not final words, but concluding words for this session on this question of where do we draw the line?
I think I align fully with Stephen and Fernandez. AI can inform your decisions, but it must never own them. And I think one of the things that, as lawyers and, partners in law firms, you have to be really clear about, and it needs to not just clear in your head, but clear as in documented, is to be really explicit about where AI stops and human judgment begins. So that means really clearly defining which tasks require mandatory human review, how decisions are escalated, how AI outputs are challenged when something doesn't feel right, especially because AI hallucinates a lot and produces either inaccurate outputs or outputs that are just totally made up, right? And there've actually been some legal cases in the US where the evidence that was provided was actually AI hallucinating and making up different precedents and things like that. So just really being careful around that. On top of that, you really need, as an organization, to have clear layers of governance that focus on ethics, that focus on transparency and fairness. So making sure that your oversight mechanisms also really are geared towards understanding how models are trained, how decisions within the models are made, and how data can also skew the outcome of what you're doing, right? So if, for example, you feed an AI particular data about a case where women always lose that case, the outcome of doing that will be, that this is going to be the outcome, right? And by doing that, you've created bias in your system. So you need to make sure that you have a plethora of data that actually goes into it in order to really get really good results. But all of that really boils down to making sure that you have the right governance. So responsible AI in law is really not about slowing down innovation. It's really about protecting trust. And trust is still human, right? It's human-led, and it's still the most valuable asset, I think, in most professional services.
Thank you so much, Ikem Dilim. I like how you put it. Be sure about where AI stops and where human judgment begins. And like Fernandez said, no matter the data you've gathered from AI, just know that once it leaves your table, it's on you. So you're responsible for whatever it is you've put out there, wherever it is that you've gotten it from. So I want to say a very big thank you to our speakers. Before we let you go, we'd like to take a few questions. We're going to take all the questions in the chat box for this panel, but I've noticed some, and I think we've actually answered some of the questions in our deliberation so far, but I'll just pick out two. Well, I crystallized two into one, then I would pick out another one. The first one is a very interesting one I want us to really answer. We're talking about future forward, and someone is wondering in the chat box saying, as a lawyer that wants to transition into tech, which area do you think is future proof? I'm also considering a tech program for LLM. So you're just wondering, is there any area that is safe, basically, from AI? So I think Ekene should take this question.
So I think it's really about, sort of the human experience, right? And to Fernandez's point earlier, and I think one of the previous speakers in the previous panel mentioned it as well, right? It is the experience that you have that gives AI context, right? Or the information that you're generating, right? Which means that if you are a more senior lawyer, you probably are able to get better results out of it because you know what the outcome should look like, right? Those functions are not going to go away. Verification isn't going to go away and suddenly become AI-based, right? There's too many AI-generated deepfakes and all of that out there. So I think really figuring out what is that human in the loop, and a lot of that boils down to things like ethics, being able to really understand and also point out bias, being able to, just have that empathy and humanness that humans actually have, right? So I think all the things within the law that humans do and that makes, the system more human, those are the areas that you'd focus on. And I know this is not really a very specific response. So it's not like, oh, pick this and then, it will work, because I think all of that is still evolving, right? When you think about also the societal impact of AI in terms of, a lot of job losses, there's no junior level jobs anymore in most professional services. So how do you even build that pipeline? So there are a lot of issues, but I think that's where the opportunities are, right? So figure out what are the things that AI is actually taking away, and by taking things away, what are the opportunities that it is creating, and figure out how to play there. And obviously AI law itself is really, I think, an emerging field, because that is where most legal cases are going to come from. And that's what we're already seeing, right? Whether it's Disney, having a legal case, or, different Forbes suing, one of the models, Amazon suing Anthropic for, using AI agents to purchase and, kind of beat the system because it learned the algorithm. So I think that's really where I see a really big future, and advising firms also on how do you actually navigate all the compliance that comes with this, right? I think compliance is going to be a really big area of focus, in at least in the next 10 years, right? So maybe those are some areas to sort of focus on.
Thank you so much, Ikendelim. These are really, really good insights. So ethics, compliance, the human aspects of things, bias, and like she has rightly said, an emerging area of law, AI law, because, lawyers will never go hungry, don't worry. It's just for you to just make sure that you are keeping in touch with information out there and seeing where the gaps are, so that, we can pushing ourselves to fill it. I know we are spending time, but I feel like it's worth it, because we are getting so much, so much knowledge that will be helpful to us. So let me ask the next two questions to Stephen and Fernandez. So Stephen, can you talk to us? Someone is asking something about security. The question is, the issue of security of information fed to AI is what still bothers me. How can one secure information on AI? And then the next question is for Fernandez. How can a lawyer quickly ascertain genuineness of a law report obtained from AI? So, Stephen, please go first with your question. And then we
Thank you, Tony. Can you hear me there?
Yes.
Yeah, great. Unfortunately, I have to move on, so I can't turn my camera on. But I can't answer that question. So, in terms of information security, in one sense, the security of information and the privacy of information, it remains the same challenge as it does today. It all arises by virtue of the question of where the information is stored. And with cloud-based technology, information can now be stored anywhere in the world and can move very, very quickly. The way we've architected our AI in TrialView is that we ensure that whenever data is stored in a particular jurisdiction, we provide guarantees, sovereign guarantees to the clients as to which locality that data is contained, where it is stored. And insofar as AI is employed, that the AI essentially is applied to the data in that jurisdiction, and the AI does not transmit or remove or in any way communicate the data into another jurisdiction. So those guarantees actually can be currently made today. And insofar as there was a requirement, for example, to store data locally, there are models available which can use AI on a local basis. Although I have to say those models are more difficult to implement, and they are by their nature more expensive. But at the end of the day, in fact, the real challenge is not AI. I think the real challenge is that we have now live in a cloud-based world where you have multiple jurisdictions and where data can be moved very, very easily between one jurisdiction and another. And that in that regard, we are in the hands of the big legal tech giants who run cloud computing around the world, Microsoft, Amazon, and Google, essentially. And we rely upon them to manage our data, and that is the actual reality of most cloud-based applications. So I don't think that's an AI problem. In truth, I think it's an existing problem, as a problem which I think at the moment there's satisfactory safeguards currently in place.
Yes, I want to add to that before I answer my question. So a couple of months ago at the SLP, one of our series, we talked about how you can have some of this, how you can manage to get some of these offline AI models and set them on your PCs or devices so that you're not really connected, your data is not stored on the cloud. So that's something that you can look into. Well, they're expensive, they're relatively cheap, they're different models that we can look at. I'm sure I was trying to get the link to one of the videos, but I couldn't get it. But I'll send it before hopefully before we send out the information. The next point is, if you cannot ascertain you try to use the best AI, you try to use the person that has the best security, but in some cases you can't. So what do? You are taking out sensitive information from information you feed from the AI. It could be that you could hash some items. They are hashing software that you can use to hash certain information, or you can manually, take out information that you wouldn't want out before you filter it manually before you put it on any of those AI that you can't trust, so that even though you are getting the answer to the problem, you're not giving out information that you shouldn't give out to. If you're doing it manually, of course, it's not an easy process. It's something it's stressful, but you should go through that if you want to put that information there and take it out. If you have a large document, you need to take out the names of parties, you need to take out the software, you need to take out some code or anything that needs to be done. There are software that you can use to actually hash out all the relevant data. If you're not using those software, you're doing it manually, you have to go through that document and move all the relevant document. There's a control find, control replace, etc., and all those other ones that you can use on a regular device. But that's taking it to the very basic level. For the question on how can a lawyer be able to quickly ascertain the genuineness of law reports, if they cite any law report, go and check the law report. That's all.
Yeah.
For Nigeria,
That's where human judgment comes in, right?
Yes, for Nigeria, luckily for us, we have Law Pavilion and the other one that are online. Most of them are online. If you have a subscription, go and check it. He said this one, go and check it and read the case to be confirmed. It's really the same thing we used to do when we were younger, where a younger lawyer would do right authorities and then you send it to your senior will look at it, he'll tell you, bring a copy of that law report, you look at the law report, and sometimes you realize that a dissenting view is the view that you have referred to and not the main decision of the court, maybe this other thing. So it's important that you, as the person, go there, find the document, read it, confirm that it is yours before you use it.
Yeah, thank you so much. Thank you so much, Fernandez. A very big thank you to our panelists, our second session panelists. You've done great justice to all of our questions. We've learned so much about how to be intentional in our use of AI. We've learned about the pitfalls. We've learned about the tools available. We've learned so much, and I believe we have a lot to go back to think about and implement in our practices and in our transactions. So at this point, I would like to hand over the baton to the Vice Chair for our closing remarks as we round up today's webinar. And for the questions, don't bother if we couldn't pick up your questions, they'll be answered. So I want to encourage our speakers to go into the chat box, the Q&A box, to answer any question that they feel they can do justice to while we round up today's session. Thank you. So over to you, Genevieve.
Thank you so much, Toyin. And for those of us who joined us late, just a reminder, my name is Genevieve Nwodoweke-Jones. I'm the Vice Chair of the British Nigeria Law Forum. and I'm also a corporate and commercial partner at Kingsley Wood Solicitors here in the UK. I just want to say my sincere thanks to all our exceptional panelists for the generosity of your time, for your honest reflections, and your really, really practical insights. I think everyone can agree that we have all taken one or more things away from this conversation. And conversations like this remind us that the future of the legal profession is not just something that simply happens to us. It's something that we actively need to shape. So thank you so much to our panelists. I'll also like to extend our thanks to our joint hosts and collaborators, the Nigerian Bar Association section of business law and section of legal practice, in particular to your chairs, Ozofo Gemudia and Mrs. Folashade Ali SAN. Thank you so much. Cross-border collaboration is something that we breathe within the BNLF, the British Nigeria Law Forum. It's something that we are committed to building. And today is a really clear, strong example of what that looks like in action. So thank you so much. To everyone who's joined us today from the UK, from Nigeria, and from beyond, I just want to say thank you for your time. Thank you for your thoughtful questions and your engagement. These conversations are definitely richer and more impactful because of the diversity of perceptions we have in the room. So thank you. And to everyone who has worked behind the scene, my colleagues at the BNLF, the Executive Committee, to the Executive Committee of the SBL and the SLP, all the technical teams, communication, technical support. I say thank you so much, because events like this do not happen by accident, and it is your dedication that continues to make this work possible. So finally, I just want to say thank you again to everyone for really believing in the importance of preparing for our future with intention, by embracing innovation, leveraging, as we've heard just recently in this panel, technology responsibly, and really investing in collaboration across borders. So thank you so much. And please keep an eye on our socials for future events. This is, as Mrs. Folashade Ali Sayan and Ozofu said, this is not the last of the series. There will be definitely many more to come in future. So thank you so much, everyone. Have a good rest of the day.
All right, thank you so much, Genevieve. So by way of just an outro, for those of you that join in later, my name is Oluwatoyin Asada. I am the co-chair of the Lagos Committee of the British Nigerian Law Forum, and I'm also the managing partner at Sunesis DLP. And it has been my, privilege and a great pleasure moderating today's session. I've learned a lot myself, and personally, I'm going to take it back to my firm. We're going to take actionable steps, and I hope that everyone on this call, on this webinar, it's going to do just the same, so that we can truly be future-ready lawyers, and be ready to compete in this beautiful, evolving world of technology. All right, so I would like to say a very good afternoon to everyone, and I wish us a wonderful rest of the day. Thank you once again to our distinguished hosts, the MBA, SBL, and SLP, and our wonderful speakers for your time and the insights you've shared. I wish every one of us a wonderful rest of the day. Bye, everyone.
Bye.
Thank you.
Thank you.